I'm Louise Norbury-Robinson. I work at Walker Morris. I'm a Senior Associate in the Commercial Dispute Resolution team, and I'm also part of the Technology and Digital group here at Walker Morris. I'm here today to talk to you about combating cyber fraud. May seem a peculiar topic for a lawyer to talk about, but actually there's been two recent cases which have really upped the game in terms of how the courts are reacting to and dealing with cyber fraud, which I think is quite an exciting time. So, the fact that cyber fraud is on the rise is well documented, and to date, so too has been the reality, really, that pursuing criminals through cyberspace and actually recovering any assets is fraught with legal, practical difficulty and risk. Apart from the obvious jurisdictional uncertainty in relation to combating fraud that's been perpetrated over the internet, there's also the question of, well, how do victims pursue defendants when their identity is unknown? How do you collect evidence or trace assets which exist only in digital form and which are perceived to be capable of deletion just at the click of a button? And often the question we're asked is, well, do the upfront costs that a defrauded victim would have to find, do they really justify, a worthwhile investment, or actually is it just throwing good money after bad? What we find actually with banks, insurance companies, and other businesses, they're really concerned to ensure their reputational and customer care needs are met, and for that reason, quite often they foot the bill, they foot the loss when there is a fraud attack. For example, the obvious example is with a bank, where their customers may be defrauded and the bank will provide a refund within certain parameters. So it's reassuring for those sorts of businesses to know that actually, from a couple of these recent really high-profile cases, the law is keeping up now, or at least making good strides in that direction. I think the tangible action against fraud in cyberspace is actually becoming more widely understood in the judiciary and more effective and therefore more worthwhile from a cost-risk perspective. So firstly, I'd like to just run you through very briefly, if I can, the two cases that I'm referring to, and then I'll end with some sort of practical tips as to how we can best protect ourselves and what action we might be able to take if we are unlucky enough to be under attack. So the two cases are AA versus person unknown and Fetch.ia, again against persons unknown. So I'll refer to them as AA and Fetch respectively. Now, AA was a judgment which was published just before the COVID attack in early 2020, if anyone can cast their minds back to that sort of time. It feels a lifetime ago now. And it's a really interesting case that pulls together a lot of issues which victims of cyber fraud, cybercrime can face, and confirms that the courts are taking steps in the right direction to offer practical solutions. Fetch was very recent, that's this year, very recent indeed, and it develops the law in this area even further. It shows that the courts are actually willing to overcome potential legal, technical, and even procedural hurdles where they can, to ensure that justice can be served for these victims of this essentially faceless fraud. So in AA, the victim company had received a ransom demand from unidentified hackers. They'd hacked and encrypted the business's computer system. In order to recover their computer systems, the company's insurer paid the Bitcoin equivalent of around $950,000 US, so that the system could be decrypted and trading could continue. The insurer then sought to recover the defrauded assets against persons unknown, that is, the hackers in this case, who were controlling the accounts into which the ransom monies were paid. And they also claimed against the Bitcoin exchange itself. Now, the Commercial Court of England and Wales were able to make orders which made it possible for the insurance company to discover the identity of the defendants and hopefully to facilitate the preservation, tracing, and hopefully ultimately the recovery of the lost cryptocurrency. Now, there's some really interesting legal and practical points from this case. Firstly, we probably all know that generally cases will be heard in public, but there are exceptions to that. And here it was pretty clear that the publicity of the case itself could tip off the hackers and enable them to dissipate the Bitcoin and potentially delete other damning information. There was also a concern here that the publicity could trigger further attacks, either revenge attacks or even copycat attacks, if it was in the public domain. And the third consideration was the court had obviously been provided with quite a lot of confidential company information to determine the issues, and that confidentiality should be maintained, the court held. So in that case, it was appropriate for the hearing to be held without notice, i.e. without notice to the persons unknown, but also in private. So that was interesting. The second issue here was service of claims. So when you issue a claim, you've got to serve it on your defendants, which is obviously tricky if A, you don't know who they are, and B, you don't really know where they are, potentially. But there are, again, exceptions to those usual service rules, both of where you can serve and also service outside of the jurisdiction. So in AA, it wasn't clear which jurisdiction these defendants were based in. The Bitcoin exchange defendant we knew definitely was outside England and Wales, appeared to be China or the BVI Islands. And the court found that these claims fell into what we call the jurisdictional gateways under the CPR, which is another talk in itself. But essentially, it was appropriate, the court found, for it to make orders for service outside of the jurisdiction and for service of the claims by emails, at particular email addresses, in addition to some other service provisions. The third thing this case was interesting about is that it was for proprietary injunctions, which people tend to get confused with freezing injunctions. But a proprietary injunction is something that stops a person from dealing with specific assets in which the claimant has a proprietary interest. They attach to the assets in question, as opposed to a freezing injunction, which attaches to the people, the defendants themselves, and it gives a greater security in that respect to the claimant. And in many ways, they're less intrusive than a freezing injunction, which may disrupt trade. It just stops you dealing with that particular asset, and therefore the courts are a bit more able and a bit more sort of ready to award those injunctions. And there'll also be various other orders that you need as well to go along with them. So that was an exciting time that the insurer sought the proprietary injunction in relation to the Bitcoin, and the court agreed with previous authorities that the Bitcoin could be the subject of proprietary relief. Crypto assets can be property, they can be an asset, which was helpful confirmation. The court also granted various other additional injunction applications in relation to disclosure of information, getting information from the banks, for example, which was really important in this case to enable the claimant to stand the best chance of a good outcome. That was also a key issue in the second case, which is Fetch.ai. That's the recent case this year. Now in Fetch, the hackers, this time gained access to private keys, which were associated with cryptocurrency accounts that the claimant held. So the hackers managed to remove the cryptocurrency from their accounts because they had the key, and then sell it on at a massive undervalue, presumably to co-conspirators, which caused a loss to the claimant of something like $2.6 million. So clearly the claimant applied for and was granted proprietary injunction and a worldwide freezing order and a bunch of disclosure orders requiring all the relevant third parties to provide information to assist in tracing these assets. Now again, pausing there, from Fetch, there are a number of other legal and practical points that really came out of it. Again, as I said, the court confirmed that cryptocurrency is recognised as property under English law, which means it can be the subject of a proprietary injunction. The judge also decided that the claimant's private key, which was stolen and enabled them to perpetrate the fraud, That private key constituted confidential information. It could be classified as confidential information, which enabled the claimant to then pursue a breach of confidence claim as a cause of action, which was helpful. The other big issue, as with the first case, it just wasn't known here in which jurisdiction the hackers were based. They knew that the currency exchange defendants were in the UK and the Cayman Islands, but the court quite readily overcame any potential service of claim difficulties by finding again that these claims fell within various of the jurisdictional gateway exceptions in the CPR, which was just really helpful. The court specifically acknowledged actually in this case, which was really good, that actually although you generally need exceptional circumstances to allow service by alternative means, to allow one of these exceptions to the usual service rules to prevail, the court acknowledged that actually the cryptocurrency cyber fraud type cases really do tend to be an exceptional circumstance. And they made the point that especially if, for example, service under the Hague Convention for Service Abroad, if those rules were to be applied in the usual way, that could take weeks and even months. And the court recognised that that's just not an appropriate time frame in cases like this, where you need to act pretty quickly before these unseen people manage to dissipate the assets, or using the internet as a shield. So that was really helpful. The court also ordered a couple of other orders, a Norwich Pharmacal order, which is named after the case that it was invented from, if you like, which is a disclosure order for various information, and also something that's called a banker's trust order. A bit more limited than a Norwich Pharmacal, but it essentially requires banks or other financial institutions to disclose account information, which obviously can be really effective in a fraud claim, and that one can also be made outside of the jurisdiction, whereas a Norwich Pharmacal can't. So lots of really helpful moves in the right direction from the courts in those two cases. And to sum up, I'd just like to give some sort of advice for businesses in these situations. But unfortunately, the encryption and ransom scenario in AA is relatively common. I think certainly I've got experience, not personally, thank goodness, but experience of these happening really quite frequently, where the hackers manage to take over your systems and a ransom is payable. Otherwise, they threaten that the data will be lost. So what can we do? And also the Fetch case is obviously an increasingly common sort of push payment fraud. And we're seeing quite a lot of these types of issues. I think in terms of prevention, first of all, customers and clients should be advised of the risks. Forewarned is forearmed, and information really is key. If people know what to look for, if they educated, so they know what these sorts of frauds look like, feel like, then they're obviously in a much better position to prevent them. Staff training, again, is vital. Staff should be trained to recognise and react appropriately to the risks of these types of fraud. And staff should know the existence and terms of whatever the business's policies and procedures are and reporting requirements. In terms of the operation of the business itself, if you're sharing internally information and data, make sure you're doing that in a secure way, but also don't underestimate the importance of actually sharing internally if there have been attempted attacks and what they look like. I think businesses have a sort of a tendency to keep that information in a closed circle, and actually what we're finding is that the customers, the clients who share that information widely amongst the business and say, look, this is what we're looking at, it just helps to raise awareness, and then all areas of the business are alive to any suspected attacks if they occur. As we said, policies, procedures, reporting requirements should be reviewed and updated quite regularly. One of the downsides, or many downsides, but one of the key features of cybercrime is that it's sophisticated and fast moving. The fraudsters are really clever at harnessing technological advances for criminal purposes and keeping up with that technology, really at the cutting edge, which is why they managed to get away with it, unfortunately. So being alive to that, updating the policies and procedures to reflect that can only be a good thing. One tip we had from a client actually was undertake regular online checks to make sure your own firm, your own brand isn't being impersonated. Whilst it may not be you that would be the victim of that, it can only help to know if your firm is being impersonated in some way, which is a relatively simple online check. Also, I would say if firms or where firms are facilitating home and mobile working, incorporate that into your business continuity plan. Have a business continuity plan, which is useful for all manner of reasons, but this is one of them. What would you do if you couldn't come into the office, for example? What would you do if the systems went down? What is that backup? And test it regularly to make sure that everything works when it needs to. I would say electronic communication, clearly that's a part, integral part of how we all work now, but encrypted emails or password protected portals really do offer a much greater level of data security. And if sending funds, bank account details perhaps should be confirmed in person or on the telephone. So before you send the money, just ring the person on a number that you know to just check that those details are correct. And any instructions to give payment details, security details, passwords, always treat those sorts of things with the absolute utmost caution. You can't be too careful in that regard. Turning to what do you do if you find yourself a victim of fraud? Obviously follow your internal incident management regime, notify the police if appropriate immediately, and also notify any lender or insurer or any other parties to the transaction or any sort of interested or industry bodies. Seek immediate legal advice. Certainly Walker Morris, our commercial dispute resolution team, has got significant experience in fraud claims and would be able to urgently initiate a proprietary or a freezing injunction just to try and preserve those stolen assets. I can't stress enough how important it is to act fast in those scenarios. If it's 10 o'clock on a Sunday evening, so be it. You need to be moving pretty quickly with those sorts of applications. But also from a prevention perspective as well, understanding where your data is stored. For example, if you've got cloud storage, do you understand what the terms of that contract is? Are you happy with that provider's risk profile? Because wherever your data is, obviously there's some risk attached to that. So if it's not something that you're currently managing yourselves, you should still keep an eye to make sure that you're happy with the level of risk and the attitude to risk of those providers. So that, in summary, cybercrime and fraud are risks that are on the rise, but so too is the knowledge, the technological means and legal expertise required to effectively respond and combat them. And the courts are seemingly keeping up too, which is not something we're always able to say. So that's really positive. The best means of protection for your business, your customers, is always going to be proactive in your data protection and security practices, and have expert legal assistance in your corner just in case anything does go wrong. Very happy to discuss further. There'll be a link to a sort of takeaway piece that we've done on this issue, and my details will be on there as well, as long as anybody in the Walker Morris wider team. Thanks for listening.